They laughed before I even finished standing up. My brother's attorney, a man in a suit that probably cost more than my monthly rent, actually turned to the mediator and smiled. Not a polite smile. The kind you give someone when you already know the outcome and you're just waiting for them to figure it out. My brother didn't even look at me. He was leaning back in his chair, one hand resting on the conference table, the other scrolling his phone like this was a dentist waiting room, and not the day our father's estate was being divided. I had a manila folder, a legal pad, a pen I grabbed from the cup on my kitchen counter that morning. He had 2 attorneys, a financial consultant, and a paralegal who kept refilling his water glass. The mediator looked at me over her glasses and said, "And you'll be representing yourself today, Mr. "Yes," I said. "I will." My brother finally looked up from his phone. Then he laughed. Not quietly, not under his breath. He laughed the way people laugh when something is so absurd it doesn't even deserve a real reaction. His lead attorney placed a hand on the table and said nothing, which was somehow worse. The paralegal looked at her notepad. I sat down, opened my folder, and uncapped my pen. I want to be honest with you about something. 6 months before that morning, I didn't know what the word fiduciary meant. I didn't know the difference between a revocable trust and a testamentary one. I had never read a probate filing in my life, but I had time, and I had a reason. My father died on a Tuesday in March. I was 29, he was 61, which is too young, and he went fast, a cardiac event, the kind that doesn't announce itself. He was here, and then he wasn't. And the whole thing was so sudden that for the first 2 weeks, I mostly just sat in his house, going through old photographs and trying to remember the last real conversation we had. It was about a lawnmower. That was the last thing we talked about. He wanted to know if the self-propelled model was worth the extra $100, and I told him I didn't know. I'd never bought a lawnmower. He said he'd ask my brother. My brother's name is Derek. He's 4 years older than me, and for most of our lives, we got along the way brothers do when they're not particularly close. Birthdays, holidays, a phone call every few months. Polite, functional. I never disliked him. I just never fully knew him. What I didn't know, what I had no reason to suspect, was that for the last 3 years of our father's life, Derek had been managing his finances. Dad had a stroke in 2021. Minor, the doctor said, but it affected his processing speed. He tired easily. He got confused by paperwork. Derek lived 40 minutes away from him, and I lived across the country. So it made sense, it seemed to make sense, that Derek would step in and help. I sent money when Dad needed things. I flew out twice a year. I called every Sunday. I thought we were sharing the responsibility. I found out at the reading of the will that we were not. The estate attorney's name was Gerald Forsyth, and he had the kind of office that smells like old paper and careful money. Dark wood, brass fixtures, a clock on the wall that ticked loud enough to hear. He sat across from me and Derek and read the document our father had signed 14 months before his death. Derek received the house. Derek received the investment accounts. Derek received the business. A small commercial cleaning company Dad had built over 30 years, 12 employees, steady contracts with 3 office complexes in the county. I received a savings account with $11,000 in it and a storage unit in Tempe containing furniture my father hadn't used since 2019. I remember not reacting right away. I remember thinking there must be a second page. Gerald Forsyth looked at me the way people look at you when they've delivered difficult news before and they've learned to just let the silence sit. Derek said, Dad made his wishes clear. He didn't say it unkindly. He said it the way you state a fact. I drove back to my hotel and sat on the edge of the bed for a long time. Then I started making calls. The first attorney I spoke with told me that contesting a will is expensive, time-consuming, and statistically unlikely to succeed without substantial evidence of undue influence or incapacity. He wasn't discouraging me, he said. He was being realistic. His retainer was $15,000. The second attorney said mostly the same thing. Her retainer was $12,000. The third told me that if I couldn't afford representation, I should consider whether the emotional cost was worth the financial one. I hung up the phone and sat with that for about an hour. Then I thought about my father asking Derek about the lawnmower. I thought about Sunday phone calls where Dad sounded tired in a way I told myself was just age. I thought about a Christmas visit where he mixed up a story he'd told me a dozen times before, not dramatically, just slightly wrong in ways that made me uneasy. And I'd told myself it was nothing. I thought about the fact that a man who spent 30 years building a business with his own hands had left that business entirely to one son and $11,000 to the other. And I had never, not once, heard him suggest that was what he wanted. So I decided I was going to figure out what happened. Not with $15,000 I didn't have. With time. I had 7 months before the estate would be settled. I started with probate law, YouTube, legal aid websites, the state bar's self-help resources. I printed things out and highlighted them. I made a notebook. I learned what I needed to file and when, and I filed it. A formal notice of contest, which bought me time and triggered a mandatory mediation. Then I went deeper. I requested the full financial records for my father's accounts from the last 4 years. This is something you can do when you're an heir in a contested estate. Derek's attorney objected. The mediator overruled it. What came back took me 3 weeks to go through. My father's main checking account showed normal activity through most of 2021. Groceries, utilities, a recurring donation to his church, occasional transfers to a savings account. Standard. In November of 2021, 2 months after Derek was officially named as his financial helper under a power of attorney, the pattern changed. There were transfers I didn't recognize. Not huge amounts, not at first. $400 here, $800 there. To an account I couldn't immediately identify. Then they got larger. $1,200, $2,000, a recurring transfer of $1,500 every single month beginning in January 2022. Over the course of 26 months, my father's liquid savings decreased by just over $63,000. The account receiving those transfers belonged to Hargrove Property Solutions, LLC. I spent 2 days trying to find Hargrove Property Solutions. There was no website, no business registration I could find in my father's state. No listing, no address, no phone number. It was registered in Delaware, which meant it was designed to be found by no one. I paid $40 for a registered agent search. The LLC had been formed in October 2021, 1 month before the transfers began. The registered agent was a corporate filing service, which is common and tells you nothing. But Delaware requires a named organizer on formation documents. The organizer was Derek. I sat with that for a long time. Then I called a forensic accountant named Patricia, who charged $300 for an initial consultation and $300 more for a written summary of her findings. I told her what I had. She asked me 3 questions, took notes, and called me back 4 days later. "What you're describing," she said, "is a pattern consistent with financial exploitation of a vulnerable adult." She put it in writing. I also went back through my father's medical records from 2021 and 2022. His stroke had been classified as mild, but there were follow-up notes from his neurologist, notes I requested and received as next of kin in a contested estate, that described something more complicated. Reduced executive function, impaired judgment in complex decision-making. A note from a follow-up in March 2022 that read, "Patient may benefit from additional support in financial and legal matters." The will had been signed in February 2022. 1 month before that note, the attorney who drafted the will was a man named Glenn, who operated out of a strip mall office and whose bar record showed 2 prior disciplinary complaints, both dismissed, but both involving elderly clients and estate documents. I wrote everything down. I organized it into sections. I created a timeline going back 4 years, and I printed it in color on paper I bought at an office supply store at 11 o'clock at night. When the mediation date arrived, I drove to the building, took the elevator to the 4th floor, and walked into the conference room carrying my manila folder. My brother was already there. 2 attorneys, a financial consultant, the paralegal with the water. And then the mediator called the session to order, and I sat down, and she looked at me and said, "And you'll be representing yourself today, mister?" "Yes," I said. "I will." My brother laughed. I uncapped my pen. I let him finish. The opening 20 minutes belonged to Derek's lead attorney, a man named Clifford, who had clearly done this many times and was very good at making a reasonable-sounding argument feel airtight. The will was valid. It was witnessed. Dad had known what he was signing. My father had over many years expressed frustration with my absence, the distance, the infrequency of visits. He had, Clifford said, made a considered decision to reward the son who had been present. It was a good argument, delivered well. I wrote notes while he talked. When it was my turn, I didn't lead with the LLC. I led with the neurologist. I passed copies of the medical records across the table, one to the mediator, one to Clifford, one to Derek's second attorney. I had highlighted the relevant sections in yellow. I waited while they read. Clifford said the records showed a mild stroke with normal recovery. I said, "Page 4, 3rd paragraph, March 2022. 1 month before the will was signed." The mediator read it. The room got quieter. I moved to the financial records. I had organized them in chronological order with a cover sheet summarizing the total transfers, the dates, the amounts, and the destination account. Patricia's written analysis was paperclipped to the back. I put a copy in front of Clifford. He looked at it. He looked at the cover sheet. He turned to the 2nd page. Then he set it down on the table slowly, the way you set something down when you need a moment to recalibrate. "These transfers," I said, "total $63,420. They were made from my father's personal account to a Delaware LLC formed 1 month before the transfers began. The organizer of that LLC is my brother." Derek said, "That was for household expenses." His attorney put a hand on his arm. "Household expenses," I said, "would appear in my father's checking account as payments to grocery stores, utility companies, home repair vendors. I have 4 years of bank statements here. His household expenses averaged $940 a month. The transfers to Hargrove Property Solutions average $1,500 a month, and there is no corresponding documentation of any service or expense they represent." Clifford asked for a recess. We took 15 minutes. I sat in the hallway on a bench near the elevator and drank the coffee I'd brought in a thermos and looked out the window at the parking garage across the street. When we went back in, something had shifted. Clifford was more careful. Derek was not looking at his phone. The second attorney, a woman named Sandra who had been quiet until now, asked me about the will's execution. Was I prepared to argue that my father lacked testamentary capacity? I said I was prepared to present evidence that the will was executed during a period when his own neurologist had documented impaired judgment in complex legal and financial matters, and that the attorney who drafted it had prior disciplinary complaints involving elderly clients. I was not a lawyer, I said, and I was not here to render a legal conclusion. I was here to present facts. Sandra wrote something on her notepad and showed it to Clifford. He looked at it. Then Clifford did something I had not anticipated. He asked to speak with his client privately. They were gone for 45 minutes. I ate a granola bar in the hallway. The paralegal came out once for water and didn't look at me. When they came back, Derek sat down first. He looked different. Not defeated, not yet, but smaller somehow, like something had gone out of him. Clifford said they were prepared to discuss a revised distribution. I said I was prepared to listen. What followed was 2 hours of negotiation that I'm not going to walk through entirely, because parts of it were genuinely tedious, but here is what matters. By the end of that session, the estate settlement had been restructured. I received a 50% interest in my father's business. The cleaning company, the contracts, the equipment, the goodwill he spent 30 years building. Derek retained the house and the investment accounts. The $63,000 in transfers was treated as an advance against his share of the estate and deducted accordingly. Hargrove Property Solutions, LLC, was voluntarily dissolved within 30 days. The mediator noted for the record that a referral to the state's Adult Protective Services Division was being made based on the financial documentation presented. I drove back to my hotel that night and ordered a burger from the place down the street and sat on the bed and ate it and tried to figure out what I was feeling. It wasn't satisfaction exactly. It wasn't relief. It was something quieter than both of those, like a room that had been loud for a long time had finally gone still. My father built that company by waking up at 5 a.m. every day for 30 years. He drove a white van with his name on the side of it. He learned the names of every employee's children. He showed up. He deserved to have someone show up for him. I think about the Sunday phone calls. I think about how many times he said he was fine. I think about the lawnmower. I should have asked more questions. I know that now. I know that's something I'll carry for a long time. But I also know that in that conference room, with my manila folder and my color-coded timeline and my highlighter and my $40 Delaware search, I did something real. I told the truth about what happened. I let the documents speak. My brother hasn't called me since the settlement. I don't know if he ever will. I don't know exactly what he told himself to justify those transfers, what story he built in his head about deserving more, about my absence being the same thing as indifference. I do know that the 12 employees who work for that company still have their jobs, that the 3 office contracts are still active, that the business my father built is still running. And every morning, when I sit down to learn how to run a company I never expected to inherit, I think about a man who started with nothing and built something anyway. And I think about standing up in that conference room. And I think, yeah, it was worth it. If you're in something right now that feels impossible, if someone is counting on the idea that you don't know enough, don't have enough, won't push back, I want you to hear this. You don't need to know everything. You need to know more than they expect you to. That's enough. That is enough.